Welcome to today's webinar. This is the third in our Advertising, Media, and Brands Global Compliance Challenge series, which began in November 2022 and will finish later this month. 2022 presented unique challenges for businesses operating across the media, advertising, and brands industry. Aside from the impact of the pandemic, we saw a changing and challenging landscape due to the increasing economic, consumer, regulatory, and compliance pressures. We expect this to continue into and through 2023. We are hosting 4 webinars to support the advertising, media, and brands industry in navigating these challenges. My name is Joe Grasser. I'm a Palo Alto-based partner in Squire Patton Boggs' intellectual property and technology practice, and I will be your host. Today we'll be focusing on anti-counterfeiting, brand protection trends, and some other hot topics in the advertising, media, and brands industry, such as trademark strategies for Web3 and private prosecutions as a brand protection tool if there's time. Without further ado, I would like to introduce my colleagues who will be covering the topics in today's webinar. Carlton Daniel and Paolo Becconcini both specialize in intellectual property and technology. They are joined by Jens Petri, a partner in our international dispute resolution practice, and Marisol Mork from our litigation group, to discuss anti-counterfeiting and brand protection trends. In terms of hot topics, 3 more of my colleagues from the IP&T group, Deborah Lodge, Sandra Mueller, and Carrie Lee, will look at trademark strategies for the digital world and Web 3.0. Last, but by certainly no means least, Hannah Lamming, a partner in our government investigations and white-collar team, will provide an overview of how private prosecutions can be an effective tool for brand protection. So let's just jump into our first topic and hear from our colleagues about anti-counterfeiting and brand protection trends. Paolo and Jens, let's start with you.
Welcome everybody. It's a pleasure to speaking today here and discussing these hot topics with all of you. I've been working in anti-counterfeiting for more than 17 years now, and I've worked with enforcement professionals and authorities around the world, including Europol, and that was in particular an interesting experience. I can call myself today an Europol accredited expert for IP crime. This does not only allow me to wear this cool hat, I hope you can see it, but also gives access to the Europol platform for experts, which is a very great tool in the fight against counterfeiters because it provides a great network of IP enforcement professionals around the world, also from the administration and the authorities, and also is a useful platform to exchange information on trends in anti-counterfeiting globally. Counterfeiting has become a huge business. There is a study from the EU IPO, this is the European Intellectual Property Office, together with the OECD, which evaluated that in 2019, the trade in counterfeits globally amounted to more than 400 billion euros. The value of counterfeits imported into the EU alone in 2019 was evaluated to be 119 billion. This shows that, I should add that this is a very profitable business. For example, margins in this business, they were estimated to be even higher than they are in drug smuggling. And this makes it obvious that this counterfeiting business today is run by organized crime. And I mentioned the profit margins, which are high, while the risks are so low. Still today, the criminal penalties are, I would say, ridiculous compared to the profits that are out there. The counterfeit networks operate extremely professional. In this context, for example, it did not come as a surprise that during the pandemic, it did not take long until the first COVID-19 related fake items appeared, like, for example, test kits or vaccines. Another example how professional counterfeiters operate, we faced this back in 2007 when we investigated websites that sell fake watches to the German market. We tried back then to identify the servers where the content was hosted that was used for these websites, and after several rounds of investigation with several customs authorities, public prosecutors' offices, and other online investigators, we found out that the servers changed every 8 hours, which made it literally impossible for us to identify the origin of the content. We made it to Russia, Latvia, and then to South America, and until we found out that for some point in time the website went through servers there, it wasn't there anymore, and it was impossible to identify the root cause. One aspect that you should also note in this context is that the fight against counterfeiters, it's not a level playing field. There's an imminent imbalance that you always must take into account, because the brands that try to enforce their rights, they are bound by the laws, while the counterfeiters do not care about the laws. So this is another aspect that makes the fight very challenging. And when you investigate counterfeiting networks, I would say that ultimately it always ends in China when it comes to the production. Or I think you would agree to that, Paolo.
Jens, hi everybody. Yes, I agree with you. Just before I tell you why I agree with you, I just make a short intro. I specialize in anti-counterfeiting, among other things, and in particular in China IP and anti-counterfeiting. I have lived in China for 17 years. Now, I currently live in the United States, but our Swire team in China, the team I head and lead, is still very active and operative in China. China remains, I think, according to the latest stats, I remember it was China and Hong Kong account for 80% of the manufacturing and export of counterfeiting goods. And Hong Kong is there because Hong Kong is not a place of manufacturing of counterfeits, but it's obviously a key transit place for export of counterfeits from China. In particular, based on my experience also in Southeast Asia, Hong Kong is a harbor that it's important for distribution in Southeast Asia, in fact. China presents in itself a lot of challenges when you go fighting counterfeiters. The first challenge, of course, the first one that comes to your mind probably is the language, the fact alone that they speak a language that almost nobody knows outside China. The problem starts even before you find counterfeiters, and it's when you need to protect your portfolio. So I have found cases where people wanted to enforce trademarks in China against counterfeiters, but they didn't have registered trademarks in China. So the first challenge is to know the laws and the rules for obtaining protection of IP in China. And that's something that starts even before you go tackle counterfeiters. So having a clean portfolio, registering the right IP, sometimes it could be a trademark. Sometimes you have something that is not possible to trademark. And in the US, you would say is a trade dress. Maybe in China, it's not protectable as trade dress because in China, we maybe don't have such a strong trade dress protection. And therefore, you need to look at copyrights. So it is already challenging to build up a portfolio that then you can enforce against the infringers. Why do we want to enforce it in China? Because you think, okay, well, I'll wait for the goods to come to Europe and I'll seize them there, or to the United States and I'll seize them there. The reality is that seizures by customs or police in the United States or Europe account for probably something less than 1% of all the goods that in the end land into the markets. So it is key and critical to balance strategies and have also a China enforcement strategy in place that hit directly on factories and traders, because they won't be deterred by a seizure in Rotterdam or in Long Beach, because they will keep doing things there because nobody's stopping the factory that making the good. They'll make it good with another shipment the day after to another port, or the same port, and this time it will go through because customer won't see that one. So having a strategy for China, it's important. When you enforce in China, of course, you meet challenges. The Chinese government, the Chinese authorities, the police, they won't actively pursue counterfeiters because they don't have, even if they wanted to, frankly, they wouldn't have the manpower considering the huge border and the huge territory of China, the dissemination of manufacturing capacities over thousands and thousands of square miles. And also because it's not how their system is designed. So they may launch some campaigns. They did it a lot for piracy or copyrighted movies and stuff. But it was back in the 90s. There's some campaigns here and there for tobacco or some more safety sensitive goods. Reality is, if you're a fashion brand, if you're a consumer goods manufacturers, if you produce luxury products, you need to do it on your own. You can't expect the authorities to go and find fakes and report them to you. You need to set up and have an investigative team, and that's what we do for our clients. We have a very strong investigative setup. We go find the factories, we go find the warehouses, and then we choose the right tool to enforce, as long as you have already a good portfolio there that we can use against those counterfeiters. Last thing that I can say as a challenge is, if government doesn't intervene in your favor, it's more possible that they might intervene against you. So I'm talking about local protectionism, that we have obviously areas where it's more difficult to enforce. And there you need to have know-how to go around those local protectionist forms of, I don't want to say corruption, but definitely less, where authorities are less interested to pursue IP crimes because they worry about other things in their agenda. They have a political and economic agenda. Even the police, at the end of the year, they have to achieve certain goals and things. And maybe for that year, IP is not in their priority. So how to go around this? Well, we have the experience to do that. For example, by building good relations with certain authorities, we can send them even 1,000, 2,000 miles away to make raids in another city, so far away from their seat, so that we overcome the local protectionism of that city. So these are all challenges, obviously, we face when we try to enforce against counterfeiters in China. But I would say we do it, and many brands do that, and with a certain degree of success as well. And it's possible.
Thank you, Paolo. And we understand that the big challenge stems from e-commerce, and I briefly touched base earlier on the brand owners' fight against websites and the big online platforms, let's say 10 years ago or so. And when the brand enforcement professionals then ultimately were so happy to make great progress on that field, and were able to take down entire websites with the support of courts, and forced the big e-commerce platforms like Amazon and eBay to do proactive monitoring and filter already counterfeit offers before they even get online. And then, social media came, I want to say, and the whole battle started over and over again, and at a totally different scope. When then the counterfeiters detected Facebook, Instagram, TikTok, and other platforms for their purposes, then suddenly the brand owners were confronted with an immense increase of platforms that they needed to monitor, and huge or masses of offers of counterfeits directly addressing consumers. And this also related to the fact that today counterfeits in South America, they are sold through TikTok or Facebook, and they are shipped directly from China in small consignments. And this is also very difficult to detect for customs. So when it comes to enforcement measures in the context of social media, I would say it's all about speed and efficiency. So you need to have a sophisticated service provider with whom you cooperate, and it's clearly a mass business that you have to engage in to fight this back as you can. when it comes to brand protection in this new online world, I don't want to say much about this because I know that my colleagues Sandra and Carrie will speak a little bit more about this in a few minutes. But I would also say in the fight against counterfeiters, social media is not only bad. There are also some different angles to look at this, and maybe Paolo, you can give us a view on that.
Yeah, it's kind of one of the few good news that I can give. It's from the investigative side. For us, that we investigate infringers, especially of me, that when I do it in China, social media or platforms can be a mine of information. So, and I noticed in the past years, social media has come up very strong, but that can be also weakness for an infringer, because infringers tend to provide in social media, in particular, a lot of personal information. We have had cases, and Jens knows some of these cases. We work together when we identify people and we found out where they were, for example, their location, and we could trigger actions because they were telling us where they were in the moment with nice pictures, and or people that provide photos of warehouses or landmarks that can lead us to places. So I want to say, I welcome that from the investigative point. Of course, it is a play, taking them down, it is a cost, but it helps also when you go find the source, because again, they are a mine for us where we can mine out information for enforcement. Obviously, when people ask me, how do we stop counterfeiting online? Well, I say, we can't stop counterfeiters. I mean, if you take, the person who asked me is a brand normally, right? What do I do to stop? And I said, well, you can't stop counterfeiting, neither on the ground nor on social media, because, and here I go back to what Ian said before, you know, the comparison between counterfeiting and drug trafficking. Asking a company to win the battle against counterfeiters in China in particular is like asking the parents of a person who died because of overdose to go and fight the cartel of Medellin. So it requires the involvement also of the Chinese authority, more engagement, or in general, the global authorities in all the relevant countries, because we're not talking about China only. I can tell you, I have been involved with a brand a lot in Vietnam, and I see the surge and the growing of the same problem in Vietnam. Of course, China remaining the major spot. For online counterfeiting, definitely there's a necessary evil, which is online takedowns, try to clean up the platforms. There's a positive side, which is, well, still collect information, because that will lead you to more work on the ground. And therefore, I think one of the key takeaways when you talk about online counterfeiting from my enforcer's perspective is we need all to make a better effort in coordinating online investigation, online takedowns policies with on the ground activities. And it's challenging, because oftentimes online platforms collect data that are very important for their purpose of taking down and monitoring social media and e-commerce, but maybe not so relevant to me on the ground. So it's always a game where we need to learn from each other what our capacities, and create programs that can combine very well the benefits of both sides. And that's what we do. And Jens and I, we do this a lot with many clients, and we try to help them on their ground. Now, stopping counterfeiters, again, it's not a company's goal. I think a company's goal should be reduce the impact of counterfeiting on my brand. And this can be done. And you can go and set up in a way that you can go back and tell your board and your owners success stories. And I think it's key to coordinate online and offline from my perspective, of course. And there are new trends to do that, especially in China, a lot of contingency fee litigation against small infringers that we do, because the deterrence of a lawsuit in China can be very strong compared to just a takedown, because we all know you take down today, they may pop up tomorrow with a different name. But if you have the physical person who's doing that in your hands, and you do something with a stronger deterring tool, like a lawsuit, for example, they will have more to lose, and they will be deterred at least to attack your brand. And that goes back to what I just said. Winning for us means reducing the impact of counterfeiting on our clients' business. So that's what I think it could be. There's always, you can't just leave alone online anti-counterfeiting and hoping that solve your problem. They will not. But you need to put it together with offline strategies.
Thank you, Paolo. And maybe quick wrap up. And I understand that we had not enough time to touch all the issues in sufficient depth. So maybe for the audience, if you're interested in any of the aspects that we had just mentioned here, just put it in the Q&A section, please, so that we can address this maybe later on after the Q&A session, or just shoot an email to us, and we are happy to go into much more detail on any of the issues. Maybe a few takeaways from what we just said, and to sum this up a little bit. So, Paolo, you correctly said that you cannot stop counterfeiters or can stop the issue. I think your goal as a brand should be to destroy the profitability. If you are good in pursuing the networks and you prevent them from making profit with your brand, the best that you can hope for that they resort to other brands. And then they say greetings to my competitor. So that should be the goal, that you should focus on destroying profitability. I think the fight must be global, and I would call there are 4 pillars that you should take into account in your fight. So online investigation and takedowns, as we just discussed, then raids and investigations on the ground, customs applications for action so that customs can seize fake goods. And the last pillar I would call is consumer education. So if you are able to convince the people that they should not buy fakes, that's also a big win for you. And this usually works very well if you can demonstrate that fakes can create health or safety risks for the people. And by the way, this also has the positive impact that you get much better attention from the authorities, and they better support in your fight. And as Paolo already indicated, in this fight, data collection is key. You have to build databases with all the intelligence that you are gathering. And this is in particular important to identify the targets who are responsible for these masses for online offers, that you then can tackle them on the ground with raid and investigations. And this is how you then will create the successes that help you to improve like the business opportunities for your brand and fight back the counterfeiters and hope that they stop using your brand. I think that was all from us here for the moment, and I'm happy
All
to
right.
hand back to you.
Thank you to Jens and Paolo. Just mindful that we want to stay on track. Carlton and Marisol, just to ask you each one brief question. Carlton, Jens and Paolo both focused on trademarks as a way to enforce brand protection. Are there any other IP rights that you see out there as advantageous for IP rights owners to protect when going against counterfeiters?
Thanks, Joe, and I promise to be very quick. The answer to that is yes, absolutely. Trademarks are the focus, and that's what we've heard about. But what I would say is it's not just about trademarks. Think about the whole ambit of IP rights. So think about passing off, which essentially is unregistered trademarks that can be protected in the US, in the UK, by building up a reputation, also in the EU through unfair competition. So passing off. Think also about design rights. They can protect aspects of the shape or the configuration of a functional product, not necessarily surface decoration, but certainly how the product is looks. And then also think about registered designs. They can protect the appearance of a product. So think about its colors, its materials, its shape, its ornamentation. And those chunky suitcases, for instance, the ones with the little animals, they're protected by registered designs. They can last for between 3 and 25 years, and can be a really useful tool in the armory against counterfeiters. Think about patents. If an invention is novel and it's clever, it can qualify for patent protection. Generally, protection lasts for about 20 years. So again, that can also be an effective tool in combating rip-offs. Last two things to mention, confidential information. We quite often find in these cases where a counterfeiter is infringing, it's because they've somehow had access to the legitimate product. So if they've done that, and that, for instance, might be a breach of confidence, perhaps they were a consultant or an employee. Think about using the law of confidence there. The EU and UK laws have been beefed up recently to protect trade secrets, so that's an even stronger armory. Lastly, counterfeiters, they're not that clever sometimes, and they will get things wrong. And to the extent they're getting things wrong, for instance, in their marketing claims, why not get the regulators to do the job for you? So report them to the regulators, for instance, for incorrect labeling, for incorrect advertising claims, for misleading advertising claims. And in that way, you can get the authorities to take action against your competitors for you. So in summary, think about all of the rights, passing off, design rights, patents, confidential information, regulatory stuff, but of course it's trademarks, which are usually the most important thing.
Thank you. And I think in particular the law of confidence is a really powerful tool to remember that you have there. Marisol, as I'm sure the audience can tell by my accent, I'm more familiar with the laws of the United States, and I was thinking, given our discussion so far, might be helpful to update the audience on what's kind of developed in the U.S. and trends with platform liability for counterfeit goods.
Oh my gosh, sure. So platform liability right now, there have been calls from Congress in the last few years to open up the doors to allow for platform liability. Historically, platforms have been shielded from liability for anti-counterfeiting and all sorts of other, issues that happen on their platforms by the Communications Decency Act. That is up for review this year by the U.S. Supreme Court. It is going to be a blockbuster year, I think, in terms of media law here in the United States because of the review that's going to happen. So we are going to have to see how potential changes in the law regarding a platform's ability to moderate content and perhaps liability for content on their platforms will impact brown consumer interactions on social media platforms. We will certainly keep this audience abreast of those developments.
All right. Well, thank you so much. And I think with that, we'll transition to kind of the hot topics with again my colleagues Deborah Lodge, Sandra Mueller, and Carrie Lee. I'll start with you, Deborah, talking about Web3 and the metaverse. You know, I've heard that referred to as the new frontier for IP. What does that mean as like a real boots on the ground kind of practical matter for business folks?
Hi, lovely to be here today. And what that means as a practical matter is that the IP area continues to be fascinating and expanding. So watch out because one never knows what's next. For NFTs, there are many copyright and trademark issues that are presented. For brand owners, they can be a new frontier, a new medium, product extension. There are many opportunities here. There are also potential danger zones for brand owners, as is shown by some recent litigation in the U.S. You may have heard of the Meta Birkins case or the Tarantino Pulp Fiction case and the Nike versus StockX case. In all of these cases, the plaintiffs are asserting that NFTs that were sold or published by or used by the defendants violated the traditional, copyright or trademark kinds of rights of the plaintiffs. And the defenses in these cases really go to the essence of, well, what is an NFT? Does anybody really know? And, they claim their artistic expression, First Amendment, fair use, and parity. In Meta Birkins, for instance, Hermes claimed that the NFTs depicting, the famous Birkin handbags infringe its trademark and copyright rights. The defendant claims, oh no, it's artistic expression, and no one would ever be confused anyway. The judge denied cross motions for summary judgment in that case, and actually the trial is set to start on January 30th, so we will have more guidance then. And another issue pertaining to NFTs is who owns the rights anyway? Are they derivative works? Who is the creator? Again, we have to await for more, judicial guidance. But recently, the USPTO and the Copyright Office have published a notice that they are conducting a study, and there was a Federal Register notice published in November. Anyone can submit comments regarding the issues up until February 3rd. But the notice asks for public commentary on many NFT-related issues, including, what fields are they used in, what are the associated IP rights, and the challenges that brand owners and copyright owners and also patent owners are encountering in trying to protect their rights. So, stay tuned. There are day-long roundtables that have been scheduled by the PTO and the Copyright Office. But, it shows that they're so aware of these new developments, the new frontiers, and that maybe it's going to be necessary for some legislative adjustments as well. So it's all very, very dynamic.
And I think that's, to put it lightly, with this space, to be sure. What are brand owners doing currently? What's the primary strategy that you're seeing brand owners undertake to protect their rights?
Well, one positive move that brand owners can take, of course, is to file trademark applications in their jurisdictions or, through WIPO or whatever, to protect their brands when utilized, in NFT contexts. As of today, there are over 7,000 live USPTO trademark applications or registrations that refer to NFTs in the goods or services ID. A handful have registered, most of them very recent, including Blockhead Buddy, and also Playboy. So, I think many brand owners have already jumped on this bandwagon, because if they don't, possibly someone else will, and there will be counterfeiting and a lot of, downstream confusion. One practical tip is that the USPTO views NFTs not as a particular good or service, but really as a method of authenticating something that underlies the NFT. So the ID must recite the nature of the item being authenticated. For instance, quote, downloadable digital files containing artwork authenticated by NFTs. That would be in class 9. And presumably, if it were authenticating a pair of cowboy boots, that could be in class 25. More remains to be shown on this. And I'm aware that as of January 1st, the NIST classification system was also amended to include that kind of authentication concept.
Oh, that's fabulous. Well, thank you for the update on the U.S. perspective. Sandra, what are you seeing in the EU?
Trademark users in the EU are highly interested in the topic as well, of course, and the European Intellectual Property Office's 2 topmost watched webinars of 22 actually dealt with trademarks and design protection and IP strategies in the metaverse. And this is, of course, also reflected by our daily practice. We have filed a lot of trademark applications for virtual goods and services last year, developing specific brand protection strategies for our clients. And what we also see a lot now is a collaboration collaboration and sharing of IP rights by using legal tools such as licensing, co-branding, up to very creative new business models, somewhat blending NFTs, blockchain, artificial intelligence. So really exciting things. And also there's, of course, the sector of brand enforcement. Many clients are worried about bad faith trademark applications in the so-called metaverse classes, which have become a real issue. That's true. And also infringements, of course, of all kinds. Coming back to Jens and Paolo, there are metaverse platforms already flooded with counterfeit NFTs, and also infringement cases which are much more complex because they somewhat touch the boundaries of IP rights as monopolies. And Deborah brought some very brilliant examples from US case law, and we are now excited in Europe and are looking forward to some of these cases probably coming up before the European courts as well.
And what are you seeing as the biggest challenges facing people with their trademark strategies that involve NFTs or the metaverse in some way?
Oh, there are, I would say, three main challenges. First of all, of course, it's always the question, how can I make my trademark portfolio future-proof in times of legal uncertainty? And there are two questions we receive mostly by clients. First of all, will I be able to enforce my trademark registrations claiming goods in the real world against infringement by sales of virtual counterparts? Or do I have to file separate trademark applications to be on the safe side? And this comes down to the comparison of goods and services, which is a factor of likelihood of confusion and a matter of consumer perception in the end. And there's no case law in Europe so far. The EUIPO has indicated that it will very much rely on the arguments and evidence presented by the parties. So there will be a lot of room for creativity and arguments. And another question is, of course, from clients, how do you work with trademarks as territorial rights in a truly decentralized metaverse one day? And this is also very exciting. Carrie will elaborate a little bit more on this question in a minute. And another challenge is, of course, that in certain projects we have interfaces between IP law and other areas of law, such as financial regulatory aspects, corporate law, data protection, unfair competition. And in these cases, for us, it's always, first of all, important to understand the business model, which hardly ever comes on a silver plate. And on that basis, we then define the legal issues and compile usually a tailor-made legal team of experts from different practice groups, different jurisdictions who work together to find the best solution. And this leads me somewhat to my last aspect, which is communication, because a good IP strategy is, of course, always a matter of communication as well between different teams, departments, marketing, technical teams, the legal team, digital, and you may not necessarily need a metaverse chief officer, but communication between departments and a company becomes even more important if we enter the metaverse finally.
That all makes sense. Well, thank you. And finally, we'll go over to Carrie for the perspective from the UK. So Carrie, what is the filing trend in the UK with marks designed for the metaverse?
Well, nowadays, from my personal perspective, what I've experienced are clients are asking me to tailor-make their portfolio to cater for the metaverse. So we've had to file fresh applications with fresh specifications that cater for the metaverse. What we're seeing, it's been confirmed by a report by Clarivet. There was a report May 2022 that the UK IPO has been the fastest growing major trademark register in the world in relation to the metaverse applications, and they're growing at 31% in 2020 and 38% in 2021.
Wow. Okay. Now, and Sandra hinted at this, trademarks, are traditionally kind of inherently territorial. Geography matters for trademark, but in the metaverse, it's inherently decentralized. So where should I file that trademark?
Well, you're correct in saying that trademarks are territorial in nature. So in the real world, we normally advise that the trademark owners to protect their brands in those territories where they are active or currently or intend to be active in the future. The metaverse brings these new challenges because the metaverse isn't like a website that can be targeted at specific jurisdictions and usually contains some evidence as to which countries or territories they are targeted. So you can basically choose a territory to exercise your brand protection. However, in contrast, the metaverse is unlikely to be clearly associated with a particular territory. Therefore, the brand owner needs to be really careful, consider which territories to register their brands in, having to regard the peculiarities of each country selected, both in terms of registration and enforcement. So until we know the status of the metaverse, unfortunately, I can't really elaborate much more than that the metaverse jurisdictional filing strategy at this stage may closely align with the real world strategy.
That makes sense. For the time being, until we have some more guidance, just use the real world strategy. Where are these actually being sold? Where are you operating them?
Correct.
That all makes sense. Well, thank you all for covering the hot topics and metaverse trademark strategies. And now we'll go on to our last topic. Hannah Lamming will provide us some information on private prosecutions and how they can be used as an effective tool for brand protection. So I guess I'll start with the kind of most fundamental question, Hannah. What is a private prosecution?
So it's relatively straightforward to explain this because it's essentially, to all intents and purposes, it looks very much like a state prosecution. But in England and Wales, the right to bring a criminal prosecution is not reserved to the state authorities, which it is in many other jurisdictions. So a company or an individual can bring a criminal prosecution, and when that happens and it's brought by an individual or a company rather than the state, we call it a private prosecution. But similarly to a state prosecution, you want to make sure that you meet the relevant tests. You initiate your proceedings, having conducted an investigation, and then your case will proceed through the criminal courts in the same way as a state prosecution, but ordinarily with private solicitors and barristers acting on behalf of that individual or client or company.
And how have private prosecution been used for IP and brand protection in the past? How is that a tool that has been used?
So I think many people might be familiar with the fact that private prosecutions have been used in this jurisdiction for some time in relation for IP and brand protection, particularly around the creative arts and media industries. And so there are a number of these types of cases that have been brought, for example, in relation to online piracy and illegal film distribution. A couple of famous ones, the Vickerman case, the Dancing Jesus case. And then they also have been used for import and sale of devices that allow people to watch media services illegally. So we've seen, for example, Virgin Media cases and so on. But then recently, the use of those private prosecutions has expanded to other areas of brand protection. So, for example, in relation to counterfeiting. And what I thought might be helpful is to just very quickly give you a summary of a case that was brought fairly recently to show how that might work in practice. So one success story in relation to private prosecutions for counterfeiting that was brought recently was the Supreme case. And one of our team acted on that case in a former role. And so that was a private prosecution of a UK limited company called International Brand Firm Limited and two individuals who were actually Italian nationals for fraud offences. And it related to the widespread counterfeiting of Supreme clothing in the UK, the EU and China. And to give you an idea, my understanding is that there were very significant sort of shops, for example, in Chinese shopping malls, as well as on, for example, Las Ramblas in Spain, where counterfeit Supreme goods were being sold. And the two individuals, as well as the company, were subject to private prosecution in the UK. And in fact, the two individuals from Italy were prosecuted what we would call in absentia. So they were not in this country at the time. And those prosecutions resulted in successful convictions. The company was fined £7.5 million and the individuals received 8 and 3-year sentences respectively. And I think what that demonstrates is that private prosecutions in this context offer an alternative to some of the more traditional options for enforcing trademark breaches, which can be difficult to pursue. sometimes because of the multi-jurisdictional aspects, and I think, as other people have mentioned, because of the difficulties with enforcing them criminally through the authorities. And I think it might be interesting to people to just tell you some of the sentencing remarks from the judge that sentenced in that case. So he said, over 4 years, and I'm sorry, I'm going to have to read them because otherwise I probably won't get them quite right. But he said, over 4 years, these defendants hijacked every facet of the prosecutor's corporate identity. He referred to the defendants seeking to steal Supreme's entire brand identity and their marketing techniques. And he noted that the company attempted to shut down, as Supreme attempted to shut down the counterfeit operation, the defendants exploited weaknesses in trademark protection in Italy. Like ticks, they jumped from one company and jurisdiction to another and carried on regardless, all through the facade created by International Brand Firm Limited in the UK. So what you're looking at here is an ability, because you have a UK nexus, namely a UK company, to consider your options from a criminal perspective in the UK, and very effective enforcement action in that case.
Yeah. And I apologize, I will ask you to keep your response brief to this final question so we have time for Q&A. But I think I know the answer after hearing, you know, the result of that private prosecution and the size of the fine that was levied. But, you know, what are the factors that a brand owner should be thinking about when it's deciding between, you know, a civil case or a private prosecution? You know, why bring a private prosecution?
So I won't, I'll try and keep my answer really, really short. There are some differences, quite a number of fairly significant differences between criminal litigation and civil litigation. You have much more onerous responsibilities in terms of disclosure, in terms of objectivity, as well as a higher standard of proof in criminal cases. So it's not something to be undertaken lightly, and it's for the right type of case. But in those cases, they can be an excellent deterrent. So if your organization is experiencing serial or persistent criminal issues around counterfeiting, for example, or other brand protection issues, this can be a really strong deterrent. It can also operate to offer you an alternative, as I've just said, where you may not be able, for whatever reason, to utilize the civil process to secure the type of results that you need and want. There can be a number of reasons for that. People can look at loopholes. There can be different approaches. There are also different jurisdictional and evidential requirements, as well as limitation periods for criminal offences in England and Wales. And to establish jurisdiction here, you just need one relevant part of the offence to have occurred here. So it can be something that is open to you to bring proceedings in this country criminally, where you may not be able to civilly. You can, in some circumstances, recover your costs from central funds. And as well, you've got, as the outcome, if the defendant is convicted, the opportunity to seek compensation, costs, and also the state will consider whether to confiscate the individual company's benefit from that criminal conduct.
Oh, fantastic. Well, with that, I think we'll open it up to questions from the audience. If there are any questions along the way, I believe that there have been no questions yet.
There is one question that I think is for me. It's asking for any comments on the proposed shop safe legislation making platforms liable for counterfeits. The shop safe legislation is here in the United States. It's proposed legislation with a great goal, seeking to protect consumers from counterfeits on platforms. The issue with the shop safe legislation is that it puts the burden, a great burden, of marketing of policing platforms for counterfeits on the platforms themselves. And on one hand, these are fine, except for an important point that Jens and Paolo made, that when dealing with counterfeits, it's always an unbalanced fight because counterfeiters themselves don't care about following the law or following legislation in the United States. So, for example, if I'm recalling correctly, one of the requirements that's proposed in the shop safe legislation is that platforms need to verify and list the country of origin that goods are coming from. That's all fair and good, but what repercussions are there for counterfeiters disclosing and being truthful in saying what country the goods are coming from? And another issue that folks have with the legislation is that it requires platforms to undertake a challenging and expensive exercise. And again, this is a great goal, but it will be quite challenging for platforms to develop proactive measures for screening goods that are sold on their platforms, as well as creating programs to expeditiously disable and remove potential counterfeit goods. This is going to require, I think, platforms to create an exhaustive review of all goods that are sold on their platforms. When we're talking about companies like Amazon, that's a big undertaking. And the concern is that in needing to expeditiously remove sellers that may have counterfeit goods, many innocent third parties may also fall in the crosshairs of this legislation. So while I think the goals are good, it's not without its fair share of critiques, including, I think, one prominent thought leader in the United States who has said that this act will kill the internet and will kill consumer access to platforms that, despite counterfeiting activity on over the last 2 years in the pandemic, we've all benefited from being able to have access to these platforms. So it's not without tension. We'll see what happens.
Marisol, was that Eric Goldman?
Yes.
Yeah, I mean, I
Eric
think
Goldman.
Yeah, I think first of all, if you aren't subscribed to Eric Goldman's blog and you're a lawyer, you should be. It's great. It's a great marketing and technology blog. But I think that highlights the tension, that policymakers need to deal with, which is certainly you want to protect brand owners and protect consumers from counterfeit goods. But at the same time, you want to allow for broad competition. Because if the Shop Safe Act, passes, I'm no great prognosticator, but I foresee higher prices on Amazon, and in Walmart.com because, as you said, you're going to default to kicking off products off your platform, just to protect against that risk of being swept up in a counterfeit good sweep. And so a lot of innocent third parties will be swept off the platform, and prices will go up as a result.
Right. So it's no easy fit. What's the fix? Maybe more targeted legislation to protect consumers while also ensuring that we retain the benefits to online marketplaces, but easier said than done.
I'll open it up to the panelists. Are there any kind of points or issues that you didn't get a touch on during our main presentation that you wanted to make a kind of hang a lantern on to let the people know this is an important point that maybe the host rushed you through inadvertently?
Joe, there's maybe one thing I would say in the absence of questions. So on the anti-counterfeiting part, we were talking about some of the other rights available. Another practical point to bear in mind, and I suppose this also kind of runs into what are we seeing in the market. Another practical point to bear in mind is 2023 continues to be the year of customization. So alongside digitization, companies which were traditionally involved in purely B2B marketing are now finding that they're offering consumer sales, they're offering a B2C platform. And that has meant that the products are targeted at a specific group of consumers and sometimes customized, tailored specifically for one consumer. So in the fight against counterfeiters, that's pretty useful because counterfeiters don't have the time to imitate the specific customized products that we're seeing. So this is something which is fairly big, for instance, in the med tech space with drugs and devices being tailored specifically for consumers. But it's not just limited to those types of products. Customization we're seeing in the beauty sector, in the leisure sector, entertainment, consumer goods spaces. What started many years ago with customized t-shirts and mugs and so on, we're now seeing that for almost all products. So that's a trend which will continue and is useful in the fight against counterfeiters.
Can I
Yeah.
just jump in with one other development in the NFT space that I think may be of interest to everyone, involved in advertising and marketing,
Absolutely.
which is, recently in the United States, which of course is the, hotbed of a lot of class action lawsuits, disgruntled investors and also consumers have been suing influencers along with the brand owner, asserting that, some of the, crypto meltdown and all has part of the fraud and the deceptive practices were really participated in and activated in by the influencers, which I think is going to lead to a whole separate issue of, potential advertising liability under many state and federal laws, and will probably also result in a need for further review of, various insurance policies and other things. So, and this is also related to the whole NFT and, crypto world meltdown. So I just think that's something that should be on our list as a hot topic that it continues to develop.
Yeah, certainly with the number of personality celebrities, the YouTube and Instagram stars out there, TikTok stars that were, hawking NFTs and other crypto to their subscribers and their fans. I think there's a lot more to come with that. I mean, we've already seen the FTX lawsuits against, the much more famous celebrities. But what these lower level people were actually saying in terms of the representations they were making was much more egregious. And I think, Deborah, I think you're dead on. We're going to see a lot more in that space in 2023. All right. Well, thank you. First of all, thank you to my panelists. It was great to have you guys. I feel honored to be your host. And thank you all to the audience for joining today's webinar. As I briefly mentioned earlier, this is the third of 4 webinars in our series. Please do join us for our final webinar on Thursday, January 26th, when our experts will look at the rise of ESG and global workforce challenges. Thank you.